Good day, I'm Fernandez and my topic for discussion and reaction is contempt of court. The rationale behind the contempt of court is that the Constitution and the laws recognize in the court or judge the inherent power of contempt as a weapon of defense, even offense, and self-preservation. The purpose of this power of contempt is to vindicate the authority and maintain the dignity of the court and uphold the seriously grounded image of dignity and capability by inflicting the appropriate penalty of fine or imprisonment or both upon the guilty party as incident in the basic proceeding to prevent its derailment and to compel the performance usually of a positive act with the imposition of fine and incarceration unless the condemner obeys what he refuses to. So what is contempt of court? Is there a difference between indirect contempt and direct contempt? What are the penalties and remedies? Contempt of court is any willful disobedience to or disregard of a court's order or any misconduct in the presence of a court, an action that interferes with a judge's ability to administer justice or that insults the dignity of the court, punishable by a fine or imprisonment or both. It signifies not only a willful disregard or disobedience of the court's order, but such conduct as tends to bring the authority of the court and the administration of law into a disrepute or in some manner to impede the due administration of justice. Lastly, it is any act in which is calculated to embarrass, hinder, or obstruct court in the administration of justice, or which is calculated to lessen its authority and its dignity. As defined by our jurisprudence, it is defiance of the authority, justice, or dignity of such conduct as tends to bring the authority and administration of law into disrespect or to interfere or prejudice parties litigant or their witness during litigation. So in summary, contempt of court is any misbehavior towards the court directly or indirectly that brings disrespect or interfere with the judge's ability to administer justice or insult the dignity of the court. There are two types of contempt of court, the direct and indirect contempt. Direct contempt of court, as defined by the rule of court, was a committing misbehavior or conduct before a court or near it which tended to obstruct or interrupt proceedings, disrespect towards the court, offensive action towards others in court, and refusal to be sworn to and answered as a witness, which justify a court summarily adjudge a person for direct contempt, while indirect contempt is where the misbehavior, verbal or written, not in the presence of or so near the court or judge as interrupt or disrupt judicial proceedings. Essentially, they differ on the place where the contempt occur. When in the presence of the presiding judge, in the course of a hearing or judicial proceedings, or inside the court, it is direct contempt, while when it is committed away from the presence of the court or from presiding judge, it is indirect contempt. In terms of mode of prosecution, direct contempt sanction is swiftly and immediately imposed upon commission of the offense or misbehavior, while in indirect contempt, the condemner must be formally charged, allowed to comment thereto, and thereafter a hearing is held where he may defend himself and avail a counsel. For penalties imposed for direct contempt, a fine not exceeding 2,000 or imprisonment not exceeding 10 days or both if the contempt is committed at RTC equivalent or higher court, while a fine not exceeding 200 pesos or imprisonment not exceeding 1 day or both when it is committed at the lower court. If the respondent is a judge guilty of indirect contempt committed against RTC or a court of equivalent or higher rank, he may be imposed by a fine not exceeding 30,000 pesos or imprisonment not exceeding 6 months or both. And if he is a judge guilty of contempt committed against a lower court, he may be punished by a fine not exceeding 5,000 pesos or imprisonment not exceeding 1 month or both. If there are penalties, then there are remedies. The person adjudged in direct contempt by any court may not appeal therefrom, but may avail himself of the remedies of certiorari or prohibition. The execution of the judgment shall be suspended pending resolution of such petition provided such person files a bond fixed by the court which render the judgment and condition that he will abide by and perform the judgment should the petition be decided against him. The judgment or final order of a court in a case of indirect contempt may be appealed to the proper court as a criminal case. Knowing all this, the contempt of court may or may not be subject for grave abuse of discretion and authority by the presiding judge. There are jurisprudence that shows that judges faces administrative cases involving abuse of power due to enforcing contempt of court, since the contempt power could easily tempt a judge to make it exercise nothing more than a camouflage of wounded pride, a burning prejudice, revenge, or a misplaced passion, and even selfish motives by the judge. Contempt of court are appropriate judicial weapons when properly and evenly applied. However, when abused, they become instrument of oppression, sadism, cruelty, and tyranny, especially the power of direct contempt, which allows the immediate incarceration of the hapless party. It is at once a curtailment of freedom and liberty and due process under the guise of maintaining discipline and preserving the dignity of the court. The inherent power of contempt of court has a good intention to provide a system of order inside and outside the court, providing justice, but since judges are still human and sometimes blinded by emotion, especially pride, most or sometimes this power was abused, but still there are judges that uphold the dignity of their profession. As my limited experience in witnessing trial and going to court, it is common to see signage inside the court reminding the silent or to turn off the phone, as well as the proper attire inside the bulwagan, and the court martial usually remind people inside the court to refrain from talking and even to sit properly. These small things always remind us to properly behave inside the court as we consider the court as the house of the law. So we are required to behave and respect it as we are required to behave and respect any house that we enter. I also experienced judges that have high tolerance to the misconduct of a lawyer. For example, a lawyer was sitting in front taking a nap when the other cases are heard. He just called the attention of that lawyer and asked if he would like to go outside first to take a nap, and the marshal will just call him when his case will be heard. Another instance is when a lawyer kept insisting that his witness to answer questions that are misleading while the opposing counsel objects. He was thrice reminded by the judge to refrain from asking questions that are not answerable by yes or no, and to refrain from asking or letting the witness to state the content of his judicial affidavit, which is duly acknowledged and sworn the truthfulness of its content, but still the lawyer failed to do so or failed to compel. The judge, for the last time, only reminded him that if he will continue to disobey him, he will just subject that lawyer for direct contempt. Hence, I personally can say that the contempt of court power of the judge is still not normally abused by our judicial system, and still upholds the reason for that power in giving orderly and a peaceful and preserving the justice in our court.